I might just remind those who are watching this in playback to continue to keep whatever contemporaneous records that you want to keep, just to satisfy the law institutes and law societies of your jurisdiction, should you need to demonstrate in the future that you have taken in the content that is being prepared for you today. And Jenny also mentioned the importance of the feedback forms. We do value the feedback if you're able to give a couple of minutes of your time when the forms come out. It does help us plan these sessions for next year. And they're often valued, particularly in times when you can't leave the office due to some emergency. There's an agenda slide setting out what I'm going to discuss this afternoon. So what is an electronic contract? So it says signatures electronic are now a fact of modern commercial life. That was noted in 2013. It is relatively trite law to say that broadly the same laws that apply to written contracts will apply to contracts that are entered into electronically. And then the question will sometimes arise whether electronic contracts are binding. So electronic signatures and things standing in for signatures through an electronic means have been around since the early days of the internet. And in a way, there's nothing special about an electronic signature, so-called, because it's just really a kind of conduct. I mean, whatever it is, whether it's just hitting an I agree button or actually typing in your name, ultimately it's a piece of conduct, and it's entirely unremarkable as a matter of contract law that some conduct can be used to indicate assent in a contractual sense. Mostly contracts don't need to be in writing. There are specific exceptions which are well known, I'll talk about briefly. So an electronic contract will just be some conduct from both parties to the contract. Any confusion about the validity of electronic contracts tends to arise from the great variety of ways in which that contractual assent can be demonstrated. I have a story that a colleague of mine who's on the Digital Commerce Committee of the Business Section of the Law Council of Australia tells of somebody who signs very unambiguously electronic contracts, and how he does that is he actually films himself signing the contract. So he does something on screen. While he's doing that, he explains what he's doing to the thing on screen. And not only does he film it, but he actually then takes the video file of his film, bundles that up electronically with the contract that he's signed, and then sort of signs that using public key encryption. So nobody could really doubt that it's actually him, and those are the very words that he wanted to sign with contractual effect. You know, that's really obvious. It's becoming quite common for people to make their signature on like an iPad screen or a tablet screen, and provided that the technology actually one-to-one lines up the whatever you're doing on the screen with the words that are displayed on the screen, obviously that could fall apart in many ways, that can be perfectly good. And if in fact the contract is able to lock down in PDF or something what was on the screen, the form of words with the squiggles that are made on the screen, that can be used for both witnessing and signing in a fairly unambiguous fashion. You know, there are a bunch of options. Electronic contracts in the form of click wrap are relatively plainly valid and have been around for a long time. So when you're getting an update to some software that you've purchased, normally, you know, a little box will open up in the loading screen, and that will often have like a window showing some of the terms and conditions, and if you scroll down all the way you can see all of them, but you have to press OK to proceed. And so this is fantastic evidence that if the computer program is on a particular machine, then somebody with custody of the machine has actually affirmatively entered into that contract, because the code couldn't be on the computer if that hadn't happened. You know, these work very well. Whether you can implement it in the sorts of contracts that you're entering into, you know, it may require other methods. So a couple of initial challenges in relation to electronic contracts that, you know, are maybe a little tricky to get your head around, is whether there are counterparts, whether there's an original, and, you know, what happens when the contract is emailed to somebody, you know, where's the contract actually ended up. So If the contract is, let's say, wholly electronic in the most absolute sense, it's going to be a digital file that's on some computer somewhere. And this itself raises some deep philosophical issues, like what if the drive on which the file is located is defragmented? All the ones and zeros are sort of picked up from where they are and moved somewhere else, possibly in a slightly different order. Is there still an original of the contract, and what is the original of the contract? If the drive is backed up, is there an original? I said philosophical questions, and they've become philosophical questions because under the common law of evidence there was a best evidence rule, and if you couldn't actually demonstrate that there was an original contract, you'd be in trouble. The evidence reform processes that have been undertaken as part of COAG processes over the last 20 years have luckily or fortunately essentially removed the best evidence rule. So it's more for the philosophers whether there is still an original. It's not something that needs to concern a modern practitioner. We will see, however, that there are some recognised problems with electronic execution in a couple of specific cases, and the cases that are tricky are deeds and also execution by corporations making use of Section 127 of the Corporations Act. And it is convenient to make use of Section 127 of the Corporations Act. So the last question on the slide is the risk of contracting electronically worth the reward. If the contract is actually really significant, and particularly if you're going under Section 127 or the document happens to be a deed, if the value is high, unfortunately there are risks in relying on a purely electronic contract. As a banking lawyer, if we're acting for the bank and some borrower says, you know what, it would be convenient for me to execute this electronically, normally the bank would say, well, I trust you, but I've never met your possible hypothetical liquidator, and I don't know who that will be. And if they think that they can disclaim this on the basis of some flaw with the electronic method that you're offering to me now, that's not a risk I can accept. So can you get your pen, please? If the risk is high and the method is uncertain, unfortunately, you won't always be able to rely on electronic, and you won't always be able to convince your counterparty that they should. Informal and implied contracts. So there's no legal requirement for contracts to be under seal or in writing. Contracts may be oral, written, and partly oral or implied by contract. Contract 101, this isn't hard for lawyers. A contract needs offer and acceptance and consideration. The offer and the acceptance have to be communicated. If that's by post, there's special rules that apply. The same rules haven't necessarily come up through common law in the electronic space, but there's analogues of them, and the Electronic Transactions Act makes provision. The parties have to have contractual intent. Contracts that are wholly oral and partly written and partly oral, are well known. When stamp duty was a little bit different, it was quite common for very high value contracts to have a written offer and be accepted by some form of conduct, because that meant that they weren't a contract on which duty was applied. And, this is relatively well known, and certainly when the internet was in its infancy. So the trick with the non-wholly written contracts can be producing admissible evidence, not only of the fact of execution, but also of what is the content of the contract that has actually been agreed. Work out how to deal with those. So this slide relates to the Electronic Transactions Acts. Around the turn of the century, a whole of government effort was made to try and facilitate electronic transactions. This was based on an UNCITRAL model law, where in fact Australia pretty much had the pen in preparing it. UNCITRAL is the United Nations Commission on International Trade Law. Australia and Australian practitioners were a big part of developing the model law, and then when it was going to be implemented, they put in a change that was not in the model law and nobody else has adopted, which says that the person who is to be receiving the electronic communication must accept the method by which it's being made. And it seems that there was concern by the tax office, For example, that somebody might produce a valid means of electronic communication which they couldn't read, or they couldn't, rely on being available in the future. This legislation applies at the Commonwealth level and also at every state. Broadly, they're in the same form. They were modified in about 2011 to give additional clarity on common law things like the common law of contract, and also to make provision for contracts being made between automated message systems without any human intervention, which are of course tremendously important in stock exchange proximate trades, where things have to happen more quickly than a human could be involved in. So the acts are facilitative in that they're technology neutral, and that is good, but it's also broadly the problem, because although these laws have been around since 2000, still people are reluctant to use them or unsure whether they've actually succeeded in using them, because the language is really describes situations which you can't be sure in advance are going to actually be made out. And I'll go through the tests a little bit. And then electronic communication they apply to, which is defined as being images communications of information in the form of data, text or images by means of guided and or unguided electromagnetic energy. If that's not a string that you've seen before, that's the difference between the telecommunications space of stuff that's going through optic fibres and copper wires and the RADCOM space where stuff is actually travelling through the air, but it's data that's being sent. Information is broadly defined to mean information in the form of data, text, images or speech. I will say that there are occasional cases where you can get tripped up trying to rely on speech, because there are issues with whether speech can be writing, if writing is required in your statute, because the Acts Interpretation Act of the Commonwealth seems to rule out recorded speech as being a form of writing. So if you've got a contract that's being done sort of over the telephone, you might need to get people to mash the button pad or press 1 rather than say yes, if you're relying on a writing requirement in a Commonwealth contract. So the Electronic Transactions Act have provisions about no invalidity. They say nothing is automatically invalid simply because it's electronic. Good news. Provisions about signing. Any statutory requirement or common law requirement that's within the jurisdiction of the relevant legislature for a signature can be satisfied if a method is used to identify the person and indicate the person's intention in relation to the electronic communication. The method is as reliable as is appropriate for the purpose, or is actually proven to have identified the person and indicated their consent, and the recipient must accept the method. Now, it's that middle one that's going to be tricky in many cases, because it's hard to tell in advance if the method you are choosing is as reliable as is appropriate for the relevant purpose. In around 2001, 2002, I was helping out a utility provider who wanted to get people to electronically agree to variations to their electricity supply contract. And what they'd worked out is that there was sort of a special number that was written on the invoices that they sent out that was not available through other means. So it wasn't written on the meter box. The meter box number was also on the invoice. And so they were going to use this as their method to make sure that the person who was interacting with them online was in fact authorised to enter into transactions and contracts in relation to the supply contract. And we were able to say that seemed like a fair enough method at the time. Particularly because I believe they used other information that was not on the invoice, like the date of birth of the consumer, to make sure they had a couple of factors from different independent sources, which would allow them to say when somebody actually hits the OK button on screen that they do know that it's the person that they're intending to deal with. So, that can be, there are a range of solutions that you can use, but you might need to put your thinking cap on to identify something that is actually available to you in particular. If you're entering into financial contracts, particularly credit contracts, you might have obligations to carry out an identification process under the anti-money laundering laws. And if that's the case, that can be a tremendous way to have a valid contract that you're sure will be valid under the Electronic Transactions Act, because at the moment there's a thing called the Document Verification Service, which means that if you get somebody as part of the same entering into the contract flow to give, you know, their name and address and date of birth and the number of their driver's licence, you can in real time check with the Commonwealth Government, which checks with the states, whether they have in fact issued a credential that has that number and has that date of birth and has that name altogether. Now, it could be somebody who has stolen that particular credential, and they're working to make available a match-no-match photo capture regime as well, so that you would actually capture an image of, say, the driver's licence, send it in, and they'd say, yeah, that looks like the one that we've issued, which is sort of even better, because of course somebody could just steal the driver's licence or take a photograph of it, or, you know, get into the licence clubs that take photographs of these things all the time and masquerade as the holder of that licence, which wouldn't be able to be picked up. But in general, this will be a process that will allow you in real time to be pretty sure that the person who's hitting the OK button at the end of the transaction is exactly the person you mean to contract with. And for, you know, the same-day loan products, not so much personal loans, but there are a number of small amount credit contract payday loan type products that promise you on television that they'll get you money pretty quickly. They need to sign up a valid contract electronically without you having to go into a store. This can work. There's in-writing provisions. So when information is given, it's reasonable to expect the information would be readily accessible so as to be usable for future reference. Now, you've got to probably put in a little bit of busy work to make sure that you can confidently say that's going to occur, and I'll speak a little bit about document management systems later, because you can be pretty confident perhaps on the day that you actually provide the electronic information in electronic writing, but you do have to take care that in a year, in 2 years, in 5 years, in 8 years, you'll still be able to demonstrate what the writing actually was, which is somewhat easier said than done. The law also allows documents to be produced in an electronic form if a government is able to require that a document be produced, like if a tax office wants a copy of a contract. For valid production, the method of generating the electronic form must produce a reliable means of assuring the maintenance of the integrity of the information contained in the document, which is a lot of th's in a row in a sentence, and a triumph of the Parliamentary Draftsperson's Office in making sentences that kind of have a bit of a rhythm but difficult to understand. So the limitation period for deeds is 12 years, and you will be entering into contracts all the time, which, even though the limitation period for contracts is only 6 years, stuff happens during the term, so you've got to keep it for 6 years after the end of some event. I will just say that often if you've got an information management system, at some point you have to switch to a new information management system, and one thing that engineers commonly do is throw out all the metadata, or if they keep the metadata, you find that it's no longer readily associated with particular information streams. And that means that before the information system gets thrown out, if you've actually got a record that John has signed a particular contract or has done something on screen on a particular day, there'll also be a good record that nothing has happened to that document since then. Whereas if you move to a new document management system, it'll be difficult to show that nothing happened during the first 5 years, and it will be known that everything was uplifted and sort of put somewhere else in a process that was either very careful or not very careful. Just saying, if you are put to proof on the integrity of records that are maintained electronically, you might find that doubt is thrown into the system by decisions that the legal team isn't making. And in any procurement contract with the data services provider who are going to uplift your information from one and move it to another, it's important just to take care of the metadata, particularly of contracts that you might want to demonstrate later are intact. So there are some problems, not insurmountable, with the Electronic Transactions Act relying on it, and that's simply because it's intended to be technology neutral, but there's no safe harbours, so nobody actually knows whether they can rely on it, and quite often, as a result, haven't used it. But, you know, there are ways to get through this, particularly if you're able to use the document verification service in a single process. And similarly, there's service providers like Australia Post that have an app that they will promise you creates a solid link between whoever's holding that particular device and that particular credential, which can be DVS checked. So, moving to the role of electronic communications in determining the terms of a contract. Courts will generally take into account if it's asserted that a contract exists, and if there's a prima facie case that there is in fact some form of an agreement, will take into account a variety of surrounding circumstances in working out what the terms of the particular contract are. So, in a case called Mackay Sugar Limited and Quadrio, 2015 from Queensland, a person was shown a PowerPoint slide and then was produced to them the final page of the PowerPoint slide which they signed, which for the purposes of the Sugar Industry Act of Queensland 1999 was taken to satisfy the requirements of written contract. You wouldn't be very surprised about it. In Get Up Limited and the Electoral Commissioner, which was from 2010, was an interesting case. The Electoral Commissioner didn't want to take electronic signatures, but the court found that they should. This was the Gillard election. You might recall that Julia Gillard became the Prime Minister and went to the polls quite quickly, and Get Up, either out of whimsy or out of a genuine interest in democracy, decided to assist a whole bunch of people who had recently turned 18 or would turn 18 before the election to get their electoral enrolments in. So they sort of put up a web form and said, fill in your details here and we'll just bulk submit them. And there were options to take a photograph of your signature and send that into them. There were options to make your mark using a mouse, and if you've ever tried to do that, you'll find that it's a mess, because, you know, the fine muscles of the fingers and the hand and the gross muscles of the shoulder really don't do the same thing. The Electoral Commissioner said, I'm not taking that, look, they're all pixelated. And the court said, well, look, you accept faxes, and they're pretty pixelated as well. I can't find that there's any real significant evidentiary difference between the stuff that you accepted yesterday and the stuff you're saying you're not going to accept today. So the potential for identifying fraud was no different, and so they were required to take the Get Up submitted bulk electoral enrolments and process them. Somewhat interesting case. So evidence to prove the existence of a formal binding contract. As I've said, there's not a specific set of formalities for what a binding contract is. A wide range of evidence can be used to demonstrate that one has been formed. You'll see a couple of cases, if you look into it, of somebody's name being typed at the end of an email as operating as a signature. In a case called Molodisky and Vima, it was found that documents signed electronically are effective. It's the intention of the person concerned that what appears on the final copy is to be regarded as that person's signature for the purpose of authenticating the document. And you might need to run additional evidence of that, of what to demonstrate the intention, but it will often be relatively clear from the surrounding circumstances. So we know, of course, from law school and recent experience, that assurances of land must be by deed, and creations of interest in land have to be in writing and not by parole. But under at least the Conveyancing Act of New South Wales, writing and signature can be done electronically, and under the recent Section 38 capital A of the Conveyancing Act of New South Wales, it says that a deed can be electronic and can be electronically attested and assigned, which is fantastic news. Unfortunately, they've not again provided any safe harbour, so it's not clear exactly how to do that. And I will say that no technology providers have stepped up to produce something that would seem to actually capture the things that are captured by a signature of a witness on paper. That is a New South Wales only initiative at this time, but it is hopeful that it will be sorted out. I mentioned the Digital Commerce Committee of the Law Council of Australia, of which I've been a member for a fair old while, and we're still plugging away at trying to get somebody to write a regulation just to say, you know, this is okay, and also to get rid of the Corporations Act carve-out. But it's been 20 years and hasn't happened yet, but hopefully it will. So electronic signatures, they can be valid in a range of contexts. A similar case to the one that I just mentioned, the Islamic Council of South Australia and the Australian Federation of Islamic Councils from 2009 in New South Wales, which you might have seen in the papers. There were several distinct groups of people who thought that they should be the controller of the assets of the Islamic Foundation of Australia, a couple of associations, held that the word Ramsey, which was a person's name being added at the bottom of an email, could be contractual language, could be a signature. Molodisky and Vima from 1988 was about an exchange of faxes, and the faxes were found to be good. Well, you'd expect that, but until there was a case, it was not entirely clear. Torak Investments and the Australian National Airlines Commission from 1985 was about a telex being a good signature. Typed first name at the end of an email in Stewart and Hishon in 2013. eBay International and Creative Festival Entertainment's 2006 is the Big Day Out case. That was about the sale of concert tickets online. It was found, as you would expect, that the contract was binding, although actually not so good for Creative Festival Entertainment Pty Limited, because it was found that some of the terms that they'd hoped were part of the contract were not part of the contract, because those terms had not been available through the eBay site, which was actually the sort of front door. You never got the contractual terms on the ticket, which says you cannot resell this ticket until you receive the ticket in the mail. But unfortunately, that was well after the contract had been signed, and you can't add terms after the contract has been made unless further consideration is provided and there's actual agreement as to the adding of those terms. A typed email and an email from the Legal Services Board adopting a resolution to appoint a receiver was treated as a signature. These are all relatively non-controversial implementations of the age-old common law relating to signature. Making an X to demonstrate your intention to contract if you can't write has been well known from the days of the Sheriff of Nottingham and Robin Hood. There's also a string more recently of impress stamp cases. So when cheques were a thing, once a year the ATO would just set this enormous machine to punch a lot of cheques, and all of them had applied to it by printing process, applied to them by a printing process the signature of the then Deputy Commissioner of Taxation, and that was a good signature because the Deputy Commissioner of Taxation had authorised that squiggle to be applied to all those cheques with the intention of creating a contractual relationship. He wanted the cheques to be valid. There's a bunch of cases about an executive who has signed his name, or her, had that put onto a rubber stamp that goes in the drawer of the personal assistant out in the corridor, and you know, when they say, could you please bang that stamp onto this letter, then that's a signature because it's done with the intention of creating a legal relationship. When the stamp is accidentally applied without them saying, hey, can you please bang the stamp, it's not a signature. So I mean, having that thing around can create a little bit of evidentiary doubt as to whether this particular one is a valid signature, but it's just the contractual intention is the point. So Section 127 of the Corporations Act and also deeds is one of the cases where we find that signing electronically doesn't always work. One case, there's a Williams Group Australia, Pty Limited and Crocker from 2016 in New South Wales. So Crocker was the director of a company called IDH Modular, which was in substantial debt. Crocker, using a contract management system called HelloFax, signed a guarantee The guarantee was found not to be binding because they were able to put on evidence that Crocker was not in fact physically where the HelloFax system claimed somebody had done whatever electronic thing applies to apply your signature to a particular document. So I mean, on the evidence it was turned away. For the company relying on the fax and providing credit to the insolvent IDH modular, a poor outcome for them. There's probably no way they could have actually known, but you know, it's what you have to be careful about. In a case called Morgan and Toowoomba Regional Council, I mentioned that for an electronic transaction to be valid under the Electronic Transactions Act, the recipient must consent to the method of electronic service. The council generally indicated whether electronic submissions would or would not be accepted. In this case, they were silent, so that a communication sent to them with an electronic signature was found to be invalid because they hadn't said that they would accept electronic in that particular case. Case called Russells and McCardell from 2014 in Victoria, which was about a costs agreement, and the client had agreed with a lawyer via email that he would sign a costs agreement if particular amendments were made, and a document was produced with those amendments but wasn't actually signed. So there was consent and reliability requirements, but for the purposes of the relevant Legal Professions Act, it was found that there had not been a signed costs agreement. And you didn't get an equitable decision based on, you know, equity treating that as done, which ought to be done. Section 127 again, the indoor management rule. So Section 127 is an important piece of the oil that keeps the machinery of commerce going, because at common law, if you want to do a deal with a corporation, you have to actually read the constitution of the corporation and ensure that the deal is not ultra vires, and you often have to check that the corporation has actually validly agreed to do whatever it is and has validly appointed whoever's going to sign the document to do it. Section 127 says that unless you have actual knowledge that any of that stuff is missing, you can assume that it's all true and it will be binding on the corporation nevertheless. So it's really useful to be able to actually deal with a corporation under Section 127. There are, as legal practitioners, often we won't take that risk, particularly if the contract is significant. We normally actually will get the constitution and check that nothing is ultra vires. We certainly will check that the people who've purported to sign as directors or secretaries are in fact directors or secretaries of the company, because if you don't do that, you actually don't get the benefit of it. But a corporation can sign an agreement or a deed using this process. Unfortunately, the Commonwealth Electronic Transactions Act does not apply to the Corporations Act, which means you won't apply to Section 127 of the Corporations Act. In fact, if you look in the schedule to the Electronic Transaction Regulations, you'll find a reference to the Corporations Law, but the Act's Interpretation Act tells us the reference to the Corporations Law, the old cooperative scheme that applied before about 2001, is taken to be a reference to the Corporations Act. Nobody is really certain why the Electronic Transactions Act excludes altogether the Corporations Law, and it may be that the then Australian Securities Commission was just concerned about being spammed with documents authorised in a way that it didn't want. But anyway, they said we're not having it, and so the Corporations Act and also the ASIC Act are exempt from the Electronic Transactions Act. And that is a problem with dealing with companies electronically, and you know, many people you will deal with the companies. Now, some say that the common law signature rules will apply under the Corporations Act, and so as long as something is shown to actually have been signed in the sense of the impress stamp or whatever, as long as there's contractual intent by people who happen to be directors, that you can rely on that, but you're always at risk of evidence demonstrating that the impress stamp was applied without the authority. And in the recent and relatively notorious case from last year, you might also have it alleged that the two directors weren't in the same room when the signing happened. So, relatively notorious case from South Australia last year is Bendigo and Adelaide Bank against Kenneth Ross Pickard and another, 2019 SASC 123, which was one of a string of cases coming out of the liquidation and insolvency of the Great Southern Agricultural Scheme. So Bendigo Bank, which was ultimately the financier, claimed that Pickard and his wife had appointed Great Southern Finance Pty Limited as their attorney to execute a loan deed and also a guarantee by signing the application for finance. So they had underhand signed the application for finance, and this granted an attorney to the company Great Southern Finance to enter into documents on their behalf. So Great Southern Finance had two of its directors, or sorry, it's not even clear that the two directors did it, but a document was produced which bore the signatures of two office holders of Great Southern Finance, and the judge, it's quite a peculiar decision because the judge says nothing other than Carter on Contract says that if a company purports to rely on Section 127 but there's two pieces of paper with two signatures, it's just not good. There's no deeper analysis of Carter on Contract or the reason for that, and in fact His Honour also says that Section 127 is for the convenience of office holders of companies in executing documents rather than for the convenience of the counterparty who's supposed to be able to rely on the company having been properly operated. So it's a little bit of a curious decision, but having said that the electronic signatures were applied to two separate documents, he just says, well, this is void. And as the purported deed was void, he said that the contract should be construed strictly and found that there was no new consideration, so there could be no basis for finding the guarantee bound the purported guarantors because there was no new consideration, the contract already being in existence. There are a whole string of cases where Great Southern's financiers have found that they actually didn't get a good go at the people who'd signed the application forms, and a lot of them are cases of hard cases making bad law, in my view. But this one in particular has lit a bit of a fire under the platform of hopefully making someone do something about Corporations Act being excluded from the Electronic Transactions Act, and ideally making a bit of a safe harbour so we can be sure. The case also is generally regarded as throwing again into huge doubt whether guarantees and other deeds are able to be executed electronically. Now, I started by talking about people writing stuff on the screen of an iPad, and again, if there is a demonstrated good way that whatever the words are on the screen are uniquely associated with the squiggles that are made on the screen and saved in a discrete file, that can be a good demonstration that I watched you sign the document and I realised that what you were doing was intended to have contractual effect, and then I signed my name to demonstrate that I'd witnessed that, and that can be fantastic. Nobody really is making systems that do that in an electronic format. DocuSign, which is very widely used. Now, if you ask a lawyer if you can rely on DocuSign, they'll say, well, it depends. Are you on good terms with the not yet appointed liquidator of your counterparty? But they can be reliable for documents underhand if you can be sure that the email address is properly connected with the person who you want to sign the contract with. But the thing is, DocuSign, you're signing something by DocuSign, what happens is that you get an email and a document appears on your screen, and you do some stuff on your screen, and this will apply a printed form of your name to the bottom of the contract, and then you close the document. That really doesn't work very well for witnessing, because if I do that and you stand in my office and watch me do it, then later you get an email and another document appears on the screen. You have no way of knowing if that's the same document. You really don't. You'd need to be right into the code of DocuSign, and they don't make that available. And they actually don't promise you much about their service standards. They don't promise you that, in fact, you know, this document is the same as that document. They just sort of rely on you making some assumptions. but you'd need to get right into the source code. So I mean, the fact that I get a document which seems to be the one that you signed, and I witness that I saw you sign this document, it's not true, I didn't see you sign this document. That's kind of as unreliable as purporting to witness something by Skype, you know. A friend rings you up and turns on the camera and says, oh, I'm going to sign this document now, and signs the document, so I saw that, and then you get a piece of paper in the post. You don't know where it's from. Unless you're actually in the same room and can actually track the piece of paper about, you don't really know. Assuming that a safe harbour was created in a regulation, somebody could build something that would have that effect. You know, I mean, you would demonstrate something that actually creates, you know, a separate distinct copy which is signed and time-stamped or something at a particular time, and then verifies that that signed and time-stamped document is the one that you witness, and that creates a new sort of signing and time-stamp. You know, you could do it, but nobody has done it at this time. So unfortunately, I'm going to say that particularly for deeds and contracts with corporations, if it's valuable, if it's something that a hypothetical liquidator might want to disclaim, you're probably going to still at this stage take the extra time to do it by means of pen and ink. The new Section 38A of the Conveyancing Act in relation to electronic witnessing is probably helpful, but not helpful enough, because again, it doesn't give us any particular method that we can be sure actually counts as witnessing electronically, and at this stage is only available in New South Wales. So that brings me to the end of my little prepared notes about 12 minutes early. We'll have a little bit of time for questions before I pass on to the next person. Again, can I remind people who've not ticked the sign-on form, and I know that you've all been sitting here since, broadly since I started, so you will have, but for people online, just to make your contemporaneous notes of what you've watched, and I'll take any questions that there are.
James, the blockchain, I don't understand the least here.
Lorks.
That DocuSign that we were talking about, that it locks in a particular form of the document that then accessed in that same chain.
For the benefit of those online, I've just been asked a question about blockchain and whether blockchain is similar to the possible technical solution I was talking about time stamping. I'll confess to being a huge blockchain skeptic, although, you know, there's a lot of people making a bit of money. I mean, just as with the gold mining caper, if you're selling shovels, you're probably doing better than people who are using the shovels. Blockchain is a means of tracking in a untrusted environment when particular events happen involving specific numbers. It's really good if you're doing a cryptocurrency, and it's largely worthless for anything other than doing a cryptocurrency, because a blockchain will tell you in the standard implementation in Bitcoin, there's Bitcoins which are essentially a very long, complicated number, and there's Bitcoin wallets which are a different long and complicated number. And the blockchain is a list of all of the transactions between time point A and time point B, which has been signed and worked out in accordance with a system that a couple of different peers are able to agree with. And they will, the blockchain will conclusively demonstrate that Bitcoin number A, which was associated with account number B, has now become associated with account number C at time D. And this prevents anybody from trying to re-spend that Bitcoin A from account B to somebody else, because the blockchain will tell you that that no longer applies to that. But if you're trying to apply that to real world things, you need a big lookup table to work out what the real world thing is that's associated with that particular number. Works really well with Bitcoins just because they're numbers, but if you want to implement a blockchain-based system for tracking values, particularly valuable kiwi fruit or diamonds around the world, or for, you know, managing who is the holder of the legal title of the building in which we stand, What you need is a big register that says number A is associated with the title of this building, number B is associated with the owner of this building, and if you've got a big database like that, you'd call it the Land Titles Office and you'd get rid of all the blockchain stuff, which is merely a distraction but sounds cool. So blockchain would not be a mechanism for being able to work out whether person A had signed document B, because you'd actually need a list to tell you that. I'm speaking more of public key encryption mechanisms, which is a complicated but useful form of maths under which there's a number that can encode a file and produce a particular hash, and then another number that can work out whether that hash was in fact associated with that original file, but can't be used to generate the first secret code number. And these properties mean that I can sign something by hashing a document using my secret number, and other people can verify that only someone who knew my secret number could have performed that transaction. So if you get a digital copy of the document with all of its words and all of its numbers, and timestamp that and then run it through a secret hash, you can demonstrate conclusively that that document had that timestamp, and then you can continue that process. So, you know, you would be able to do that, but if you put to proof, you have to actually, you know, convince a Supreme Court judge of a whole lot of pretty recondite mathematics. But you'll get an expert who says this is for sure. Any further questions? Thank you very much for attending. Please remember to complete the forms. And also, I mean, I've got to say thanks very much for those who've come out in the current emergency. I think that we're going, unless you're going straight away, but I think in fact there'll be some afternoon tea, and there is some tea and coffee at the back, and there'll be a short break for people to collect their emails, and Jenny will be back to introduce our next speaker in about 15 minutes, I believe. Thank you.